Issue preclusion is the other side of res judicata, and it can get a little bit complicated. So this is a place where you want to make sure that you're paying attention to the standards and really just walk through them, because it can get a little confusing otherwise. All right, let's start off with a little terminology. Issue preclusion is what we call this doctrine now, but in olden times at common law it was called collateral estoppel, and actually both terms are still used. So for reasons that I don't really understand, we talk about it as issue preclusion in general, but then its different types, which we'll get into later in class, are often called collateral estoppel. So just get it down now that these are exactly the same thing. The terms are used interchangeably. You can use them interchangeably too. More important is, what does this mean? You can think of issue preclusion as argument exclusion. In other words, an argument that could potentially be made in a lawsuit is excluded from a lawsuit because it has already been determined in some past lawsuit. So here's how it goes. There's an issue that has been settled by lawsuit one. Don't worry about what it means to be settled for now. We'll get to that in a sec. But let's assume that the court in a lawsuit has determined some issue of law or fact. If that's the case and there's issue preclusion, then later lawsuits have to accept the conclusions of lawsuit number one on this issue, not on the whole judgment, not on the entire claim. It doesn't cover necessarily the whole lawsuit, but if this issue has been determined by a lawsuit, then later courts have to accept that conclusion, that determination on this issue. And that means that arguments about it, so different versions of the story that might be presented to the jury, that they are excluded from lawsuit number two, because lawsuit number two accepts the conclusions made by the previous lawsuit. So in a general way, the question for issue preclusion is, when can a party force the court in lawsuit number two to accept some conclusion on some issue reached by the court in lawsuit number one? So when does court number two have to take on court number one's conclusion about some issue? So as you're reading these cases, I think it can be really helpful to keep a few questions in mind. Number one, which party is invoking issue preclusion? In other words, which party wants to make an argument unavailable in lawsuit two, forcing court number two to accept court number one's conclusion about that issue? What is that conclusion? What did court number one conclude about that issue? The opinion you're reading, does it agree with this party that court number two should have to accept court number one's conclusion about that issue? Or does it think that the parties should be allowed to present different arguments about that issue to the jury? And why does it think so? So if you ask yourself that about each of the cases we read for this section, I think you'll get a much better understanding of it, and also understand the way that issue preclusion is cabined, the way it's constrained to particular issues rather than entire lawsuits, the way claim preclusion covers entire lawsuits. Okay, so here's the standard, and it's a little bit complicated and it's a little bit long, so just bear with me here. You'll see each of these factors play out in different cases that we read. Issue preclusion prevents litigation about an issue of law or fact that has been actually litigated and determined by a valid and final judgment that required the determination of that issue as an essential part of the judgment. So not something the court happened to say or happened to find, but something that was essential to the resolution of the issue the first time around. Issue preclusion applies if the second litigation involves the same parties, but in some situations, it even applies if the parties are different, if they fit into a non-mutual exception, because the parties to lawsuit 2 had the opportunity and the incentive to litigate the issue fully the first time around. So just as a heads up, when you are reading the cases for today, Illinois Central Gulf Railroad versus Parks is going to talk about 1 through 4 here. And Parkley and Hosiery is really going to tell you about number 5. So pay attention to that. Figure out what the basic parameters of issue preclusion look like from Parks, and then ask yourself, under what circumstances can this apply? Do the parties have to be the same? And if not, why not? And turn to Parkley and Hosiery to help you answer that question. So before you get into this, a couple of heads up about Parks. This is a case that is from a while ago, and it's using state law. So there's just a couple of things I want to get out of the way so people don't get confused. It's a great issue preclusion case, actually. It really helps you see the different configurations in which this stuff can happen, but there's a couple of things that might kind of trip you up, so I wanna get rid of them first. One is, as you're reading, you might, I hope you would, think, wait a minute, isn't lawsuit number 2 precluded by claim preclusion anyway? Why are we even here in court? And the reason is that Illinois claim preclusion law, at least at the time that Parks is heard, is different from the federal standards. So once again, the cacophony of state and federal laws rings loud and clear. But the point for our purposes is just ignore that. Don't worry about claim preclusion. If it were in federal court, it in fact would have been claim precluded, but it's not. So here we are. Issue preclusion is still a possibility. The other background issue is contributory negligence. So you'll see that in Parks, it's really important that if the plaintiff can be shown to be partially at fault, then the whole lawsuit goes down. So just remember, maybe you guys have already covered this in tort, but just in case you haven't, we have 2 types of ways of evaluating negligence when the plaintiff is also somewhat at fault. One is contributory negligence, which holds that if the plaintiff negligently contributed to their own injuries, they cannot recover, even if defendant was also negligent. The other form, of course, is comparative negligence, which says that if plaintiff negligently contributed to their own injuries, they can still recover that part of the damages caused by defendant's negligence, even though they can't recover the part of the damages caused by their own negligence. So I think it should be pretty clear, if you keep this in mind, that Parks is operating in a contributory negligence situation. And so it's very important for them to know whether the plaintiff contributed to their own injuries.